well, I will call the case, calling McMillon versus the City of Kalamazoo. This is supposed to be a 15-minute mini oral argument on the application where Ms. Akins would have argued on behalf of her client. I don't see any counsel for Ms. McMillon in the courtroom. Mr. Stemfort, you're here. Is there anything you want us to hear, or are you prepared to rest?
Chief, Larry just texted me that counsel is here. I don't know where, somewhere in the building.
Okay.
Start the time.
Yep. Is counsel for Lakisha McMillon in the courtroom?
Yes, I'm sorry. It said that we were behind, so I went and sat over there. I apologize.
No problem. But you no problem, counsel. But we're gonna get going, and we are trying to finish by noon, so we're gonna keep you on target if that's okay. Okay. And you may proceed.
I don't think that Your Honor took the time to reach out and talk about a case that has been dismissed twice in the trial court that's sort of given us a lot of confusion. I think this is a very important issue. I filed many appeals on this issue. I actually filed one tonight.
Counsel, I'm just having a little trouble hearing. I'm sorry. If you could just, yeah.
Sorry.
You can try to raise the
The
podium.
podium will
too.
go up too.
There's a button,
Somewhere.
like, to your left.
There you go.
Yes.
Okay.
That'll help you.
Yes.
Is that better?
You can raise it even more if you want. Up to you.
I think it's the mic. I know.
We're
Can I
gonna-
just make sure? Can everyone hear me better?
Yep.
Sure.
I think so.
I think
Go ahead and start. We'll let you know.
I think the time has come for the state of Michigan to get on board with the Sixth Circuit, to get on board with Title VII, ADEA claims, and allow people to bring claims within the time that the legislature has set forth for the statute of limitations to apply. I don't believe that it's a contract of adhesion if you want to get to whether it's actually a contract. There's the four main reasons that Your Honor indicated in the order that she issued in January. The time has come to overrule Timco. Ms. McMillon should not be bound by the terms of an application that stated it's not a contract. The contractual limitations that restrict civil rights claims absolutely violate public policy. And lastly, that the issues were preserved. As to the first issue, I think Judge McDonald in Timco dissent laid it out pretty clearly. I believe that there's no way that we can say that it's not a contract of adhesion to have employees and employers bargaining for things that the employee has absolutely no bargaining power. In this particular instance, as applied to Ms. McMillon, she had an application that she filled out in 2004. She was denied in accordance with the affidavit that was submitted in the trial court. They indicated they expressly denied her employment. I don't think that what she did was even an offer for them to accept. I think it was an invitation to accept an offer, for them to make an offer, and they declined it. And then in 2005, they reached back out to her and asked her to apply again. And at that time, they didn't give her enough documents. She wasn't given an application. She wasn't, and so therefore, to the extent that we're saying that even that employment application would constitute a contract, at the time, it would have ended with it. In 2005, when she came back, they asked her to come back. And to be clear, they solicited her from North Carolina, from college, to come up to Michigan to become a police officer for the city of Kalamazoo. So she came up and she went through this process. They didn't hire her the first time. Then they decided to hire her 18 months later, and they don't give her this document. Flash forward 14 years. She's suffering discrimination, which Judge Lipsey acknowledged exists in the city of Kalamazoo and is a problem. He wasn't deciding, I don't believe, on the merits of whether or not there's discrimination within that department. And so she has a claim, she files it, and Ms. McMillon, she was a detective. She knows what she needs to do, so that's why she asked 2 times, can I get a copy of my employment file? I'd like to know what you all have, what you're making these decisions on, if you're going to discipline me. And when she asked, she got the document that we submitted in our motion for reconsideration. Now, as I indicated, in the reply was the first time we actually saw the application, the employment file that they were indicating they had given to her, I guess, when she requested it. But obviously, that document is not in there. There was nothing indicating that the statute of limitations was going to be shortened for her. So she had no idea. That was the reason that she asked for it. So, flash forward, she files this suit. We come in, they say that she filed this, that she filled out this application. Now, if you look at the applications, the first one is from March of 2004. That's what they submitted in response, in their support of the motion for summary disposition. And then we said, we hadn't gotten that. She'd asked for her employment value. That's not fair, in essence. In the reply, that's when they gave us what they were calling the employment file. And if you look, there's no page number on what was in support of the summary disposition motion, but on the reply, when they said, here's the employment file, there's a page 35, which now has an April 2004 date on it, which is a totally different document, they're not the same document. And that's what the individual who signed the affidavit was indicating that she had signed in April. And so, to the extent that, once again, 18 months passed before she even starts. So the difference even there between Ms. McMillon and the Timko case is that it wasn't when she started her job. It makes it even more unfair because she didn't get the job. And then when she comes back, they don't give her this application again, and they told her she's been there for over 10 years. She knows that the retention policy is supposed to be a year, and now they have this thing from 15, 14 years later, indicating that obviously they held on to the document they had her employment file.
Counsel, if I could just jump in with a question. First of all, I recognize there was early Bullard-Plowecki claims, and obviously we could have a whole conversation about that statute and whether it has teeth or not. But that's not why we're here today. What I'm wondering is, can in an application, can some things be binding and maybe other things not? So for example, we do know that applications very frequently have a request for a drug test. That, to even be considered moving forward in this process, you have to pass a drug test. Background checks, you have to have a background check. And often those include even a waiver that there won't be any liability for past employers providing information. So that sounds pretty contractual to me. And those are used all the time. So what I'm wondering is, are those all invalid? Or is it just maybe one portion of this agreement is invalid? I'm trying to figure out the distinction.
Sure. I think it goes to the point 3 about what we're talking about here, which is civil rights violation. I suppose if a person had a civil rights violation they were alleging because of a drug test or something like that, I think that's where the rubber meets the road here, because the legislature has decided you have 3 years to bring this claim, and you should have 3 years to bring the claim. Your options are limited to take the job or don't, apply for the job or don't. At the time that she applied, again, they denied it. So if we're now talking about 2005 when she starts, we're not even in the Timko part. We're now in another part where there's no contract at all. But to answer your question, I think it's very different because we're talking about a violation of civil rights for the same reasons that I think in Logan versus MGM, the Sixth Circuit said, the whole point is for you to go through this whole, we have a statutory remedy, at least obviously Title VII a little bit different happened to that, to the EEOC.
Right, so they obviously addressed, I understand, they addressed the Timko issue, basically, for the companion federal statutes for civil rights, understood. But I'm wondering, what if your client didn't get the job the first time around, and she did a failure to hire lawsuit? I didn't get hired because of discrimination. And obviously there was this binding shortened limitations period in the application. Would she have been held to it for the failure to hire her?
Well, I think it goes back to the other points again. I think it's okay to look at it in totality of, is it a contract if they say it's not? It's an application, the first part. And then second, is it right to do that when you're talking about a civil rights violation? I would submit to you in that case if she's saying, or you say if it's on the basis of race or gender, like she claims.
Yes, a failure to hire because of my race.
Yes, I think that you're in the same territory of, it's not fair. In essence, it's not fair for the same reason that the New Jersey Supreme Court thought that it wasn't fair in
But, so, okay, so I get the, like, argument that the reason for Timco, that there's a policy reason that we should invalidate it. Totally understand that argument. But is there a separate contractual argument that she should be bound? I'm just trying to think of, for example, that waiver against other employers, that I promise I won't sue past employers for providing truthful information about my job. Is she bound by that?
Well, and I'm sorry if I'm not answering your question. I guess I still think that if you're still looking at it from a contractual, if you're looking at it from a contractual standpoint, you're saying, is it reasonable, then we're talking about, is it a contract or adhesion would make it not a valid contract?
Right, so you're saying the whole document is not a contract?
I would, yes,
Okay.
I would submit that it's not a contract.
Thank you,
because-
yes. Fair,
Is
okay,
there
understood.
is there any significance to the fact that the language said this is not an employment contract as opposed to this is not a contract?
Well, I mean, I think in her release, I think that's the same language, I think it's the same situation there. So I don't know that it would make a difference, because I don't know what they meant by employment contract. We never really got into the contours of that. But I think from a fairness standpoint, because she's giving up her right to sue for her employment, according to what they're saying, I think that's where that comes from.
So if she had said in signing that, you can, run a background check on me, and they ran a background check on her, does she have a claim that there was no contract, they had no right to do that?
Because the language about it being employment. Because it was-
Right, I mean, and I think maybe sort of trying, similar along with Justice Welch, is there a distinction between an employment contract, meaning terms and conditions of employment, discrimination arising out of employment, how long you have to bring those claims, and what the application is saying? Because you are making representations, sure, call my former employer, run a background check. Is she, by signing that and agreeing to it, is that a contract to be distinct from an employment contract? Meaning she's agreeing to be bound to those terms, but the statute of limitations and perhaps other conditions of employment are an employment contract area.
I would submit that employment contract is anything having to do arising out of the employment.
So including all the other stuff in the application.
Yes, because I'm not sure that you can separate the two of them. I don't know how you, in terms of if she's suing them because of some employment issue, I think that would make it an employment contract, whether they included the word employment or not. I'm not sure it would change whether or not she would be able to.
It's all arising in the context of seeking employment, so
And
it's,
counter that, I think that's what the employer would say, right? It was all arose out of employment, the same way the workers' comp, situation. Pretty much anything that happened there is in that area, so.
So you're reading that language as this is not a contract related to employment as opposed to a contract of employment. There's no distinction for you?
I'm not sure. Contract
I mean, I think of an employment contract as something pretty specific, related to, here's your job offer. In fact, employers all the time say, this is not a contract because of the decision in Tucson to make sure that employees don't end up in, employers inadvertently have employment contracts. So to solve that problem, employers put disclaimers everywhere saying, this is not a contract, this is not a contract. And they got in trouble because they did that on some things they actually intended to be a contract, which is what Hurtubise was about. So, I think, good lawyers have learned to separate and say, this part is a contract, but you are still at will. We have no promise of an employment contract with you. There's no, big magic contract. So it sounds like you're saying, though, that this is not a contract of employment relates to anything related to employment.
I would say that just because I think it goes back to the fairness part and the adhesion part. I think if you're actually able to sit down and negotiate some term or something like that, or I think just like you get policies and procedures where somebody starts there, it doesn't necessarily, if you understand that, okay, you could be fired if you don't do this or if you do these things, but I think to the extent we're talking about a contract between them, I don't think they can get the benefits and have none of the responsibilities that come along with contracting with somebody to say, well, we meant it like this. Because again, I think if not much room that an employee has to push back on that. We just won't get a job. And to the extent that you want to bind them, then you have to accept the responsibility that comes with binding their abilities to do things. And also, I mean, to the extent you're talking about taking a drug test, I mean, you can just decline to do that and obviously not get a job. But in the case here, this happened and something earlier that was very serious, that the judge, Lipsy, acknowledged should be deterred, and now can't come in and do anything about it because of something that they didn't tell you about. She didn't have notice of that, or we would have come in and done that earlier. You know, that I still wouldn't be in front of you, but obviously we're here because we filed it after the 9 months. And I think the issue becomes, as was argued in her life, it's just not fair to do that when you don't have any bargaining power. What is it that the employer is bound by? If there's a contract, what do they have to do? It's one-sided to that extent, and so that's the argument, I think, with respect to that.
Thank you.
And I didn't know how much time I have.
You have 7 seconds.
Okay. Can I answer any more questions first, or do I continue with my presentation?
Done.
No.
But I think
You are out of time, counsel. I'm so sorry.
Oh, I thought you said 7 minutes.
7 seconds.
I'm sorry.
Yeah.
I had a hard time.
Thank you. No. You did a great job, especially since you were flustered coming in. Thank
Thank
you
you
very
very
much.
much.
Yeah, thank you.
Thank you.
Good morning, guys. I'm a little short. Steve Van Sempler on behalf of the city of Kalamazoo. And I guess I just want to, obviously we have these multiple issues that we're addressing today. I just want to start with failure, the preservation argument. We mentioned that in our brief. We'll rest on our brief primarily for that argument. But I think it's pretty clear here from the DG that these issues weren't preserved. And so that makes it a little bit difficult for us because the record wasn't built to address these questions. And so we'll do the best we can. But I do just want to put that out there. First of all, with respect to the TINCO issue, I will say, I've looked at all the cases, and TINCO is consistent with how all these other jurisdictions do this, right? I mean, the notion that an application continues to bind an employee after they're hired is very prevalent. And you see that in the Logan case from the Sixth Circuit, the Morrison case from the Sixth Circuit, in the Rodriguez case from New Jersey. All of those cases were cases in which an applicant signed an application and then was hired, and then several years later a dispute came up. And then the question was, well, wait a minute, there's certain provisions in the application, right? Arbitration provisions, for example, in Morrison. And the question wasn't whether the application still bound the employee. Everybody assumed it did, right? Because it's obvious that it does, unless there's a superseding agreement, right? So if there's a person who signs an application and then is hired and enters into a subsequent superseding written agreement, that may wipe out the terms in the application. But other than that, all the courts agree, as far as I can tell, that the terms of the application continue to bind, particularly when there's consideration in the form of wages. Now,
Even when it says this isn't a contract?
yeah, so that's a Hurby's issue. And so for this, there's a difference between saying this is not a contract and this is not a contract of employment. And that's
An
important.
employment contract.
Pardon me?
I believe the language is this is not an employment contract?
Yeah, it's not a contract of employment, right? That's
It's a
language.
contract of employment, I
Yeah,
believe.
on
Right.
page 39B of our appendix.
Right.
And so in the Little Butte versus Malady case, for instance, it says this is not a contract. Different case, right? This case says it's not a contract of employment. And this is important to think about because we have an application here, not a handbook, not a manual, not a policy that may change at the whim of the employer. This is an application. So essentially what's going on here is, as Justice Welch mentioned, you have somebody who's agreeing to provide truthful information, to allow an employer to contact their previous employers. And what this language says, it says, look, don't expect, if you're agreeing to things, we're setting up the ground rules for how we're going to process your application and the position to which you're applying. But this isn't actually a contract of employment. Like, don't show up and think you can start working tomorrow, because there's no agreement as to payment. And so it's not saying it's not a contract. There certainly is binding terms in this application statement. but it's there to say, this is not a contract of employment. You can't show up and start working. And that's what it's doing. And
So then, why isn't the shortened statute of limitations period equally limited to this realm of the application, right? It's not a contract of employment. Don't show up, right? We're not guaranteeing, we're not saying that you got hired and we got to start paying you. But you're agreeing to these things and we're agreeing to accept your application and all that. So why isn't it more like what Justice Welch was suggesting, that for a failure to hire claim, if you're going to sue because of something arising out of this application, you have 9 months to do it instead of the full length of time that the legislature gave you? Why is that not a better read of?
And so I think the critical point with all of these, we're looking at a contract, right? So you just look at the plain language of the contract to see what the parties actually agreed to. And if you look at the terms of the contract that they agreed to, they clearly believe that these representations and agreements would extend past the date of hire, right? So even the statute of limitations, it says, any lawsuit arising out of my employment or termination of employment must be filed within 9 months. So that provision itself assumes that it's going to carry over well past any hire date. Now, of course, if this person wasn't hired, then the claim would be limited to failure to hire. But
Mr. Van Stepford, I'm wondering if you could walk me through, let's go back to like first 3 weeks of law school and contracts. Offer, acceptance, consideration. So like there's like a timeline here, right? So the first time she applies, the first time she doesn't get the job, and then the second time they invite her back. And I'm asking genuinely, I don't know the answer here. What is the offer, acceptance, consideration? And then again, later, the offer, acceptance, consideration.
So I would answer that in two steps. So number one, I think, for our purposes, right, we don't have to, for our purposes, we're dealing with somebody who was applied and then ultimately hired, right? And so Timco says, at the very minimum, if somebody's hired, the consideration is going to be the wages that are paid to this individual, right? So that's my basic answer. And I really think that's the only thing we have to do in this case. Because
The consideration is the wages she eventually got paid the second time that they revived the application out of the file.
Exactly, and that's kind of the stutter step that happened in this case, right? Which is, somewhat atypical perhaps, but it doesn't mean that this, there's no way to, the plaintiff certainly hasn't identified, well, this is when the obligations under the application stopped, right? And there's no way to say, this is when they stopped, right? They just keep on going until there's consideration. Perhaps.
So if you were to leave your current law firm and go back to a law firm that you applied to 10 years ago, and you call them up and say, I am interested in leaving Michigan and going to work in New York, and you had applied back in law school, and you submitted an application, but you ended up not taking the job. It's sitting in the file. Can they just pull that application out and bind you to it?
If I didn't supersede that, I would say probably, right? That's why I would say, if you're going in, if you're signing a new application, or if you're going back to re-up a prior application, I'd want to pull out and make sure what's on file, right? And if it was something I didn't like, then I would do something differently. I would enter into some sort of different arrangement. So that's step one. Step two, right, is this question of, well, if this person doesn't get hired, right? If somebody applies for a job and then never gets hired, does that mean that the application just didn't bind anybody?
Isn't it like a rejection, though? I'm just trying to, in a contract law, after acceptance, consideration, at some point, somebody, it's almost like who's making the offer? Let's talk about the application. Who's making the offer?
Well, so this would be here's how I would say it. I would say that the offer is being made by the employer to say, look, we're gonna consider your application. The applicant says, okay, great, I'm gonna sign this here, I'm gonna agree to the terms that are gonna control this application process. And then what we would say, right, and again, I don't think the court needs to get there for the purpose of this case, but what we would say is, I think when the employer expends resources screening the applicant, doing the interviews, calling references, here I think there's like an agility test, right? Expending those resources, that's consideration, right? When the employer says, look, because the employer could just say, well, I'm just going to reject this out of hand.
Yes, agree. So in this instance, they did expend the resources and in the end, didn't hire her the first go-around. So did they withdraw the offer then? I admit, I'm like struggling here with basic contract principles.
Yeah, so I would say that the application is still there, right? I mean, it's not like, the agreement is complete at the time that this is signed and the employer starts taking action.
So it's just an open offer forever that sits in a filing cabinet?
Well, no, it's not an open offer, right? So again, this is an agreement about the ground rules of the application process, how it's going to be handled, right? One of the ground rules, for instance, is that the applicant is going to provide truthful information. That representation, that agreement that the applicant has to provide truthful information, that extends, whether she is hired or not. Same with the representation that the authorization for the new or the prospective employer to contact previous employers and get references. Again, that extends regardless of whether the applicant is hired or not, right? And that's really important for employers because otherwise, if you contact references and then you end up not hiring the applicant, does that mean that suddenly the applicant isn't bound by her representations that she can release you from liability for contacting them? Right? That would be a pretty fraught thing, kind of a risky thing for employers. So that's why, and again, as I'm saying, I don't think the court needs to get there for this case, but as a kind of a backdrop, that's how we think this works, and that's why it's important to navigate these waters carefully.
So you've brought up preservation on some of these big picture issues. Did plaintiff preserve on sort of just the validity of the contract itself?
So the arguments that the plaintiff made were the argument with this kind of stutter step, right? The fact that there was an application in 2004, I believe, and then that application didn't go through, and then in 2005, they picked it back up and said, look, we already have all your stuff on file. We keep this stuff for 3 years. I know there's, but we keep this stuff for 3 years pursuant to our written policy. So we're not going to make you go through all the rest of the stuff. We're just going to say, okay, we know you've already done this. You've already agreed to, abide by the ground rules, and so we're going to pick you back up in the interview process, right? I think the Court of Appeals is correct, and trial court. That doesn't make any difference. I mean, they still can rely on the stuff that's still in the hopper, regardless of whether the hiring process extends a little bit beyond what they thought it might initially. That's the answer to that.
Thank you.
I can address some of the other issues if the court would like. I mean, again, on the Hurley's issue, I would say, again, it's a contract analysis. You look at the language of the document and you figure out, okay, what is this document actually disclaiming? And all it's disclaiming is that it's not actually a contract of employment, right? There's no compensation term here. This is not an agreement that says you can come in and start working tomorrow. On the public policy piece, which I'm happy to take questions about, I guess I'll just mention a couple things. The cases in which courts have found that the shortened statute of limitations are void on the basis of public policy, they all involve considerations that just aren't here in Michigan, right? Whether it's the presence of mandatory administrative exhaustion regimes, which doesn't happen here under the Marsh case, or whether it's a built-in statute of limitations, which again isn't here, we're just relying on default. Even in the Michigan Association for Justices amicus brief, they rely on a Kentucky case, which is, I think, Krogan. That case involved, there was a statute actually passed by the legislature that said you can't shorten contractually a statute of limitations more than half of the ordinary statute, right? And so the decision in that case really relied on that, and that's clear from the concurrence. They also talked about how 6 months is too short anyway, but that's not what the case. That's not what the decision rested on. And then in California, the other case that Michigan Association for Justice relies on is the Ellis case. California, again, there was a mandatory exhaustion regime. And same with the rotary case, right? We have that. We talked about that in a brief. So I would just point out, and as we've done in our brief, that none of those considerations are here in Michigan, so none of those rationales map on very well at all. What we really have here is we have a situation, it's kind of like 42 U.S.C. 1981, which prohibits, racial discrimination. It's a very important thing. However, all the courts that I've seen that have looked at whether you can shorten the limitations period for a 1981 claim, they all agree you can, because the legislature just relied on a default statute of limitations, and so there was no real balance of what a specific limitation period should be. And I submit that that's exactly what has happened here. Unless the
Thank you, counsel. The case will be submitted. Thank you both.